Number 28, People v. Perdue. And just so I don't forget, for the students who remain here and have made it all the way through all these arguments, we'll take a little bit of a break and come back to talk to you if you'd like.
Good afternoon, Your Honors. May it please the Court, Carolyn Walther for Thomas Perdue. I'd like to reserve 3 minutes of my time for rebuttal, please.
Yes, you may.
Thank you. The unduly suggestive first-time in-court identification.
So, counsel, what would your rule be? What rule would you have us adopt in a situation like this?
Your Honor, the rule that we're asking this court to adopt really has several components. So the first is notice. We're asking this court to hold that when the prosecution is going to be asking a witness to make an identification of the defendant in court, that they're required to provide notice to the defense.
What if the prosecution doesn't have notice? What if they call a witness, seen this happen, witness looks out and says, that's the person that I saw?
That is, and I know Your Honor is aware of this, it's a slightly different situation than what we're encountering today.
I understand that,
notice
but you
we
want
are-
a notice requirement as your rule, so how would the rule apply in that situation?
The notice that we're seeking really attaches to the question, or the intent to ask the question. So if in this situation, if the witness sort of makes a spontaneous declaration, oh, that's him over there, that's something that wouldn't trigger that same.
It would be the same type of identification, and wouldn't it just encourage a prosecutor never to ask?
I think that would be, Your Honor's point about incentives is a good one, and we're concerned about the same thing here, but the likelihood that a witness would spontaneously sort of make that declaration without a question being before that witness, I think is
Let's say it happens, so how would you apply your rule?
In that case, I can imagine the defense making some sort of objection, maybe asking for a curative instruction of some kind to be given to the jury, but it's really not getting at the situation in this case, which was a situation that was...
If you have information provided pursuant to discovery that says there's a witness who's capable of identifying the defendant, is that notice that that witness may be called?
The notice that we would be asking for is something more specific than that. And I think what Your Honor is getting at is similar to what happened in this case.
In this case, the defense was aware of the existence of this person and that the person could, in fact, it's alleged, identify the defendant, correct?
Yes, the defense was aware that this person existed and that 5 months prior to the trial, they had indicated that they could make an identification.
So why couldn't the defense then take measures to inquire, is this witness being called? Has there been an identification procedure? And if not, ask for something or do something as opposed to just wait?
Well, Your Honor, that's really shifting the burden to the defense in a way that's not really...
How is it shifting to the defense? If you know the person exists, how are you surprised? If you know they exist and that they can potentially identify, then that is much different from all of a sudden a witness appears in court. I don't have discovery information. I have no idea who this person is. And then that person points to the defendant and says, that's the person.
In this case, the defense was never given notice that this person had been, that there had been any kind of pretrial identification.
Why does that matter here?
Person.
When they're told that the person could potentially identify the defendant?
Well, that was, again, at the outset of the case, that the witness had made this statement 5 months before. That's a very different thing than that they're going to be asked.
What is the statement? I'm misunderstanding this record then. I didn't understand that this witness had said, yes, I can identify that person as the shooter.
The witness had, at the outset, on the night of the incident, had said, I can identify the person.
But not the
To the police,
specific
but
person. is
Not the specific person. So,
No, she was not familiar with that.
without further notice, why would a defense counsel think that they're going to get on the stand and choose the defendant when they think the exact opposite?
I agree with Your Honor, and
But
the
you
point that
would
I'm
get
making is probably
notice.
not as
You
clearly
would
as
get
I can
notice
give them.
of a prior identification though, right? I mean, if there had been a prior identification, doesn't the prosecutor have an obligation to disclose that to you?
If there had been an out-of-court identification procedure, yes.
So you knew there was none here?
Here, there was none.
Isn't there something
in
in
the
the...
5 months?
Isn't there something in the record that suggests that the morning before the witness testified, the prosecutor showed the witness photographs?
There was some colloquy among counsel and the court that photographs were shown, and there was a question asked of the witness, did you look at photographs? The prosecutor later elaborated at that colloquy that the photographs were of the scene, not
Not of a person.
of the person.
I thought there was a photo array shown to the victim, is that correct?
That's correct.
But not a photo array, I don't mean photos of the scene, but a photo array.
Photo array of potential
Yeah,
individuals.
shown to Ms. Hill, is that correct?
That's correct. Police never returned to conduct any type of out-of-court identification procedure with her.
And at what, sorry, just.
No,
one
I'm
more.
sorry, I didn't.
At what point was defense counsel aware that the prosecutor intended to call the witness?
To call the witness, I believe she was included in a list of
In the list.
potential witnesses, but the substance of her testimony didn't become clear until she was on the stand.
So your view, I take it, is that the knowledge that the prosecutor might call her, perhaps intended to call her, didn't obligate defense counsel to take a look at whatever there had been 5 months ago and take any affirmative steps that there would be a notice requirement with the people? If that's right, what form would that take?
I think that the notice could take the form of, ideally prior to trial, this notice would be provided. And it would be similar to the types of notices that are provided when the prosecution intends to introduce, for example, Sandoval or Molyneux evidence. It's generally sort of a simple written notice. It's provided prior to
Counsel,
trial.
notices relative to identifications generally tend to be creatures of statute, don't they? That would be a CPL 710 kind of notice?
71030. 71030 covers out-of-court identifications. This would
Right.
be something slightly different, but it
But it's in the rubric of identification, that's the point I'm making. And I guess I just want to know, why do you think the court needs to wade into, with its own common law notice requirement, when this is generally handled by statute?
Well, I would respectfully slightly disagree with Your Honor that this is generally handled by statute, because I would submit that this court has routinely addressed identification evidence in a variety of contexts, and also the type of pretrial evidentiary ruling that we would submit as appropriate for a court to make in this case is along the lines of, again, Sandoval, Molyneux, Ventimiglia evidence that
Let me
that
ask
happens
you,
routinely before
after we
trial.
get past the note, let's suppose we agree with you on notice. What then, because Judge Garcia was asking me about the components of your rule, what are the other components of the rule?
The second component would be that the defense then could ask for and generally receive some type of special procedure that would essentially be a more...
What if the defense asks for nothing?
If the defense asks for nothing, then I think it would be likely that that this type of procedure wouldn't take place.
And so what if the defense asks, let's say, for some out-of-court identification procedure, and the judge says, but wait a minute, the witness lives in the same apartment building as the defendant would testify, or at least the prosecution represents, that would testify, she knows this person.
Then I think that would be along the lines of the decisions that the court, again, routinely makes on a case-by-case basis, that this isn't necessary because this identification would be confirmatory, or perhaps identity is not at issue in the case, something along those lines.
Does the court's discretion play a role here in your rule? Or would you take all discretion away from the court?
No, I think there would necessarily have to be an element of discretion and case-by-case factual analysis, as there is in many other similar situation.
So you're
Would that be subject to an abuse of discretion standard then on review? If there is notice given and if the defense asks for some further procedure and the court concludes, having heard from the prosecution, that that's not warranted?
Based on the facts of that case, if that were the situation and the defense were given the opportunity to make that request and the prosecution made a showing that it wasn't necessary, then
counsel,
yes, I would.
just so I'm clear on your rule, it would be notice by the prosecutor and some type of inquiry by the court, or only in response to that notice, the defendant would have to ask for some type of inquiry?
Your Honor is asking whether the defense would have to ask for
Right.
the inquiry?
Going to Judge Troutman's question, I think. So we have a notice requirement. You know that this person's going to be asked to make an in-court identification. You notice it. Then the defendant at that point has an obligation to ask for some affirmative relief.
Yes, I would say that in general, and that's how the Second Circuit has handled this in Archibald and similar cases. But in general, these types of first-time in-court identifications are extremely suggestive. And so this type of procedure is almost always going to be required unless there's some sort of showing that there's a good.
But let's say the
counsel-
people offer and say, okay, I'll do a photo spread out of court, and the defendant says no, but I don't want the in-court ID. Could they do that? Because they may not want a photo spread confirming it, right? So what happens then?
I think the court would have to rule on whether or not the photo array would be sufficient, or if the defense is, I guess, asking for another type of procedure. I think that would have to be a.
So you're saying then the defendant has a burden to make some kind of showing that the photo array is either not appropriate, or for some reason, given the circumstances, that's tainted and you either need to do something else or there's no way to cure the problem.
I think that's right, and I think,
They couldn't just say, I don't really want to take a chance that my client's picked out of a photo array, because it's a much better ID for me to cross somebody in courtroom that's looking at somebody at the table and identifying them for the first time.
well, I think it's unlikely that the defense attorney would make that determination just because of, the reasons that
I think Judge
discussed it.
Garcia is asking, maybe I'm misunderstanding, he's asking if the defense has gotten notice and then says, wait a minute, I would like to have a procedure, whatever that procedure is, and identifies a specific procedure, and the judge says, I'm not going to give you that, I'm going to give you a different one,
I see.
whether at that point, defense counsel can say, you know what, forget it. Can you withdraw your objection to the in-court identification?
I suppose so. It seems, if that were the determination that counsel were making based on the facts of that case, I suppose they could. I think we're getting into a situation where it's sort of hard for me to imagine why they might do
So
that. but
you
they're-
agree that there may be, for strategic reasons, why one procedure or another would not necessarily be desired by the defense?
in terms of a sort of an additional procedure that happens after the notice.
Or any procedure. We're assuming there was no procedure done before. You're now given notice that there's going to be a witness who will testify, and that it is believed that that witness may be able to identify you. Can a defense attorney decide that it is more harmful than helpful to have that extra procedure for strategic reasons?
Suppose almost anything could be strategically justifiable.
But in a
looking
case
at the
where-
facts of an individual case, but
You have a witness who says, I can identify this person, which I think is this case. Not your client, but I could identify the person that did this. And the police, for some reason, never go back and show that person a photo spread. And now it comes to trial and they say, I'm going to have this witness try to identify the defendant. You don't think it's a strategic call to say, I don't want a photo spread, because if they hit a court-approved photo spread that isn't suggestive, and then there's an in-court ID, I'm in a much worse position than crossing them on bad police work and you waited till the person was sitting at the table and now you're having them identify the only person it could be sitting over there.
I-
You don't think that would ever happen?
I think anything can happen, but I think that it is so, and sort of our overall point here is that these in-court identifications, when they're happening for the.
Counsel, in this case, the trial lawyer didn't ask for an in-court, some sort of in-court procedure, right? They didn't ask for a lineup or some sort of seating arrangement when they found out that the witness was being called, did they?
They didn't, but again, the attorney here didn't know that that question was going to be asked, and as soon as it became apparent that that witness was going to be asked that question, she objected, she asked to approach the bench, but at
Was
that
the
point.
witness
sort of
already, sorry, didn't mean to interrupt you.
I'm sorry, Your Honor.
Was the witness already in the courtroom and able to see the defendant at counsel table at the time the objection was raised? It wasn't obvious to me from the record. Do you know from the record?
Yes, so the witness had been testifying for approximately 10 minutes prior.
So yes.
So yes. And she was first asked to describe the person that she saw that night, and it was at that point that defense counsel objected.
So what is the only, given that, as I recall, counsel is arguing, it's on the stand, there's no way now to put this genie back in the bottle, what's left to happen? Just a mistrial?
At that point, yes, I believe it would have to.
Once they've taken the stand, or possibly in the courtroom?
Yes, because at that point, suggestiveness has already happened. It's essentially too late.
And the fact that the defendant was provided during discovery with information, body cam, that captured her saying that she could identify him, that plays no role?
It's not enough, Your Honor, is.
So the fact that you know that this identifiable person may come into court and identify your client, defense doesn't have to do anything, but the people need to do what exactly? In addition to giving that required information.
The people need to provide the defense notice that this witness will be asked on the stand, under oath, before the jury,
But it's on the body cam.
out. Even so, Your Honor, that is a very different thing than asking the witness.
Actually, it's in the right close in time. I would think that that's pretty good information that would give a calculus to the defense as to how they wish to proceed, way in advance of trial.
On the other hand, this witness then was never asked to do any kind of out-of-court identification, and so,
And usually out-of-court identifications are challenged because of a question of suggestiveness.
yes, and I would submit that this is,
Clearly, there are problems with in-court identifications, but going back to a difference between, if there's no information at all, that there is a witness that can potentially identify the defendant, that's very different from, here's discovery information, here's the witness and what the witness said on the night in question.
and our contention, Your Honor, is just that information is not enough to,
Not something for the court to consider in its discretion, what is an appropriate way forward?
no, Your Honor, because
But there might be some circumstances where there is no other evidence tying the defendant to the crime other than that identification. And then it would be pretty obvious that there's going to be an ID coming because there's no statement and you have to establish jurisdiction over the defendant. Otherwise, you would prevail at a trial order of dismissal. So in some circumstances, I think there would be notice.
But in those circumstances, then I would submit it's really still the prosecutor's burden to provide that notice
So
to
here
the defense.
there was other evidence, right? Why then not a harmlessness conclusion, even if we were to agree with you on the broader on some aspects of the broader rule you're seeking?
The identification here was not harmless because the other evidence really consisted of the testimony of the victim, and he had made a number of inconsistent
Wasn't there a
statements.
security cam video?
That video did not capture the shooting itself. It captured some of the aftermath, but it didn't show the shooting itself.
Would you
So
agree
the-
that the evidence here was at least confirmatory? It's, and I only ask that because they didn't use this witness's testimony in order to bring charges against the defendant, so
That's right.
it has to at least be, there had to be something else in the record, right?
And it was really the statements of the victim. No one else who was present that night, and there were at least 4 other people who were present that night, testified at the trial. And the victim here really made contradictory statements about how this happened, who was responsible. At first he said he didn't know, then he said he threw a drink on a girl and she shot him. He said that to several people at the hospital, and then it was only 9 days later that he implicated Mr.
Which is
Perdue.
all good fodder for cross-examination, but it was enough to bring charges. It was sufficient, it was a sufficient basis for charges to go forward, right? Without a dismissal
That-
pre-trial.
He was indicted on that basis.
Yeah.
But in most of these hearings also, you explore the suggestiveness because there's a vacuum. We don't know what happened. And there's an opportunity to explore the actions of the police to determine whether or not something was suggestive. Here, it seems to me that there isn't that vacuum because it's taking place in a courtroom with a judge who's there to make sure that the proceedings are held in a just and fair manner. There's a defense attorney there. It's significantly different, in my view, than something that goes on outside anyone's purview. And why aren't those safeguards enough here in a case where there is an in-court ID?
So there's really 2 reasons why those safeguards aren't enough. The first is the extreme suggestiveness of the overall setting. The defendant is seated at counsel table with the defense attorney. There's language.
And granted, those can all be arguments to the jury who watches the entire thing take place. That's where I'm having an issue. I understand if we're exploring things that you haven't had eyes on, but the jury is witnessing the identification happening, the judges as well, counsel is at the table, and the legislature didn't see fit to notice a scenario like this.
And the jury witnessing this is exactly the second reason why these identifications are extremely prejudicial, because the witness, because these circumstances are so suggestive, the witness is going to be very confident in pointing out that person. He's right over there. And the jury is seeing this, they're hearing this, and they're going to be swayed by that confidence, and it's very difficult for cross-examination to get underneath whether that confidence is due to circumstances or whether
But isn't that the same in a photo array when a police officer comes in and say, no, that witness confidently identified picture number 2? And at that point, there's nobody to say otherwise, whereas at least in the courtroom, a jury can assess the credibility of that person and the reliability of that identification in real time.
Well, except that with a photo array, the person who is administering it ideally doesn't know who the person is that is supposed to be identified. Whereas in a courtroom, we have a situation where not only is it clear who the police think is responsible for this, but the prosecution has seen fit to bring charges against. There's a trial taking place, and so it's very clear who the person is that should be identified. And so just the inherent suggestiveness of that circumstance, the surrounding circumstances, is really why we need these types of heightened protections for these identifications, which are essentially show-ups, but show-ups that are happening under much more suggestive circumstances than even out-of-court show-ups.
Thank you.
Thank you.
Good afternoon, Marty McCarthy for the People.
Do you agree or disagree that a first-time identification in court can be suggestive?
I believe the Supreme Court has said so, so I think I'm constrained to agree with that concept.
Okay. And If it is,
It's on the table.
is that the end of the conversation, or
No. And the reason why it's not,
could you speak up?
yeah, this is a large room. I apologize. Let me try and fill the room with my voice.
Maybe the mic a little closer.
I could try that too.
Yes.
Is that better?
There you
Okay,
go.
I'm going to lean in then. But
Lean in.
don't misunderstand my leaning in for aggressiveness. The issue is not suggestiveness. It's never been suggestiveness. The issue is whether it's unduly suggestive. And in this scenario, when you look at what happened, the record really isn't developed as to whether this particular identification was unduly suggestive. For example, the defendant, there's not much description as to what the defendant is wearing, but it's clear he's not wearing an orange jumpsuit.
But the defendant is at the defense table.
Correct.
And unlike the pretrial ID, you're now in a courtroom where the state has decided this is the guilty person. And the witness understands that. How is this not even more suggestive?
The witness doesn't know that the defendant is at the table.
Well, I think
They can assume it.
the witness may well assume it, and I thought that one of the purposes of a photo array, for example, assuming that there's nothing unduly suggestive about the way in which the photos are chosen, was to provide, a number of different options, however many you have in the array, 5 or 6, from which the witness then can select if he or she believes that the person is there. And I'm not sure how you have that in the courtroom setting.
Well, let me tie that answer to a scenario that Judge Garcia posed, which was, would there ever be a strategic reason why a defense attorney would say, do a photo array, or not to say, don't do a photo array? And the reason for that would be, in the standard for photo arrays now is double blind.
Yes.
And under the law, if a double-blind photo array is administered and the witness picks the person out of a double-blind photo array, that identification procedure, the evidence of that procedure itself, could be admitted into evidence.
I'm not disagreeing. There may be
Yeah, and I'm
reasons.
going to tie. I promise I will tie it in. So in that process, the witness has the ability to select one of 12 people in that double-line photo array. In a courtroom, this particular witness had an opportunity to select a defendant. I've seen that happen before. They've had the opportunity to select a defense attorney. I've actually seen that happen before. They've had the opportunity to select anyone in the audience, and in this scenario, this courtroom was full, according to the trial judge. This was a full courtroom. The witness didn't know whether the defendant would be sitting at the trial counsel table. The defendant could have been sitting in the gallery. Those arrangements under Archibald could have been made where defense counsel had asked prior to trial, I would like my
Most
client.
citizens do assume, even just watching Law and Order, that the defendant is sitting next to the attorney.
They don't know it. They don't know it. I believe you can say they can assume it.
Does suggestiveness require absolute knowledge? I thought that it encompassed circumstances where you are, being encouraged, whether consciously or subconsciously, to pick A over B.
Unduly suggestive, yeah. So when you consider what's unduly suggestive, in essence, what you want is the witness to take a particular person, right? Make a particular selection. When the officer puts his thumb on number 5, pick number 5.
So in the courtroom, you consider the race and ethnicity of the accused, who's actually in the courtroom in the gallery. All of those factors have to be taken into consideration. And if the accused is of one race and everybody else, to the exception of that person, you cannot tell me that that's not unduly
I
suggestive.
would say that, but here's the problem with this record. We don't know. Now, if I believe the court should have demanded, in terms of a record, that record be made, that my God, my client is the only black person in this courtroom.
Can I ask
That's
you
not in this record.
Can I ask you about the rule that counsel has proposed and where along its path, if at all, you have a problem with it and why?
So.
So it sounded
I believe
like
we
the
started
first,
with
yeah, sure, it
notice.
sounded like the first step was notice.
Yes.
And then the second step was an opportunity to ask for an alternative procedure. And the third step, I think, was for the court to be able to accept or offer some different procedure or deny it entirely with some degree of discretion.
If you were to consider that in a vacuum, let's talk about it in a vacuum. But before I do it in a vacuum, let's talk about the fact that they did not make an argument.
Oh, yeah, but
There was no notice.
I'm actually interested in the vacuum.
And in this case, they didn't make an
I
accommodation.
got the record in this case. I'm just
Okay.
wondering about that as a prospective rule.
So,
If there was some way you could win in this case, and Ms. Walther could win as a rule.
Sure.
What's the problem with?
I believe in this case I could, because he did have notice.
Trying to ask you about the rule.
He did have notice.
Okay, but
So actual or constructive notice.
how about the rule?
Yeah, let's start with that. Actual constructive, in essence, you're talking about actual notice, right? There's no statutory provision for actual notice. So then you look at, was the defendant on notice?
Okay, but sorry. The rule she's asking for is not constructive notice. The rule she's asking for is actual notice. Do you have a problem with actual notice? As a going forward rule, forget about this case. Let's assume you're going to win this case.
Well, in a sense, I don't know if I don't know if I can say I do or don't have a problem with actual notice in the sense of, because I would say that should come from the legislature. But assuming we go past that, right? And you say, you have to look at concept of notice,
Operationally, is that a
right?
problem for you?
What's that?
Operationally, is that a problem for you? And I accept your view that the legislature ought to do this. So let's put that in a basket.
Then when you look at what the legislature has done, the legislature has,
Yeah, I'm trying to ask you a different thing now. So if we were to adopt a rule, that said you have to provide actual notice, is that operationally a problem for you?
and I could conceive of circumstances where it could be.
Okay, help. Where?
I believe there was an example, I don't know who said it, of a defendant and the witness living in the same apartment building. That could be
was
an
me.
issue. Well, that was you?
Yeah.
Okay, I'm sorry. That was a good example. That could be a potential issue in terms of operationally.
Providing notice in that circumstance?
Yeah, there could be a protective order. There could have been a scenario where the ID witness is subject to a protective order, so that notice would be, the ability to give notice would be an issue in that case. So, I mean, there are
Why
certain,
can't you give it to the attorney subject to that protective order?
you mean give the actual notice to the attorney who, on condition he don't tell the defendant? Is that what you were
Yes,
saying?
I'm asking you.
Okay. But again, let's go past the fact that, I can't sit here and conceive of, other than the ones I've already said, there may be others of different operational issues with providing sort of an actual notice.
I'm curious about what the Chief Judge just said. So you have a problem with a defendant receiving notice, even though courts can grant continuance, et cetera, for the attorney to deal with it, you don't want notice.
Would say notice is not required under the Constitution.
I'm asking you, if there were a rule that was developed as a result of this case, you're saying no notice to the defendant. That's a problem for you.
I could conceive of circumstances where that would pose a problem. Whether you, in crafting that rule could
But if
either.
the rule was not absolute, so you identified a circumstance where, for example, there could be a risk, I assume, to a witness in light of a protective order. But, I think Judge Troutman suggested one way you might address that. But if that were, as a general matter, the rule, would that pose any difficulty to you doing your job?
I mean, other than the scenarios I discussed, no, I don't know. But in terms of what I can think of, other than the things that I've identified, no, I don't know. I honestly don't know.
How about if we move to
That
the-
would be, I'm sorry.
How about if we move to the balance of the rule? So forget notice for a moment. Let's say you've given notice. How would you want the procedure to work after you've given notice? I assume you would want defense counsel to say, look, I want some alternative procedure, right? If they don't request it, you would they waived it.
So you're moving on to sort of the second step?
Yeah.
Let's look how that second step had worked in Archibald, for example. In Archibald, defense attorney had asked for an accommodation. And what the court did was sort of balance what the proof would have been with the ID versus without the ID. And in that scenario, the ID was critical in that case. There wasn't DNA, there wasn't fingerprints, there wasn't video, there wasn't a signed confession. So the ID in that case was critical. So the court, in the Second Circuit, when they were talking about Archibald, really considered sort of in using its discretion, would take into account all of those things as to whether the accommodation should be granted. The scenario that I think posed itself in Brown, which was before this court like 8 years ago, was the ID, the accommodation for a witness sought for a witness who had been previously deemed reliable after a Rodriguez hearing. So the court can consider that as well. But that would be sort of the things I believe that the court would consider. And then there would be a scenario where maybe the defendant would not want the accommodation granted, like a photo array or an in-person lineup, or whatever was chosen. There could be a scenario where the defense attorney say, I don't want to do that. I would rather go through cross-examination and highlight, why wasn't this witness ever subjected to an identification procedure before? Why are we just hearing about this now for the first time? Sloppy police work, which is a typical defense cross-examination tactic of police officers and witnesses.
You're sort of, if I understand you, if I can summarize it, I think you're sort of saying that whatever the ruling by the court would be it would have discretion, it'd be reviewed for abuse of discretion, with a variety of factors the court could consider. And if defense counsel didn't like whatever the court ruled, one option would be to withdraw the request for the out-of-court identification.
But the one thing I would say, which may or may not be controversial, is this: I don't think that in terms of accommodation that this is a new rule, because I have seen trials where this has happened. So this does happen at the trial level. I just did an appeal where the defendant asked for this type of accommodation at trial. I did a trial where this type of accommodation occurred. So it does happen. The defense attorney has to ask for it. They didn't. That's really the crux of the issue of when you talk about what the rule should be and whether the rule should apply to the defendant.
What could be the accommodation? Let's get back now to this case. What could be the accommodation when the witness is on the stand?
You're talking.
Certainly, of course, if you've gotten a notice,
you're talking.
The witness has not yet taken the stand, is not yet in the courtroom. There are actions that can be taken. But what do you do once the witness is on the stand?
You're talking in the abstract, though, right? You're not talking about this particular case.
Well, that's what happened here, but we certainly.
That's.
I'm asking as a general rule.
Yeah, I don't agree that that's what happened here.
Oh, the witness wasn't on the stand?
No, that the defense attorney didn't have notice that the witness could
I'm not
identify.
asking you about that. I'm
Yes,
asking you about once the witness is on the stand.
Just want to be clear, we're
You
talking
would-
hypothetically.
Yes, we've moved past that. I'm asking
Okay,
about
good.
this.
Then I am happy to answer you hypothetically.
Yes.
Hypothetically speaking.
As well as in this case. Go ahead.
Okay, hypothetically speaking in this case.
Yes.
If the prosecutor didn't, were this scenario where I believe the hypothetical was the prosecutor didn't know that the witness could ID but then points to the person? Is that what we're talking? Was that the hypothetical? And says that's the defendant or that's the man that did it?
I'm asking about a case where the witness, like this one, the witness is already on the stand. What could be the possible way that one would cure that situation, the suggestivity of that?
Well, in a hypothetical scenario, if that were to happen, similar to what happens at trial, where somebody, a suppression issue arises at trial. If there was an accommodation scenario that could happen, the jury gets excused, the court explores the accommodation to figure out, and maybe that accommodation is different than a photo array. Maybe it's, it could be any number.
I guess I'm asking you, what would be the way one would deal with the situation when the damage has been done? The suggestivity has occurred. They're sitting on the witness stand.
See, I don't know if the.
I know you don't agree with that.
No,
Work
no,
with the
That's
hypothetical.
not what I was going to say. I was going to say, I don't know if the damage has been completely done at.
Exactly. Just assume this hypothetical.
No, I meant in the sense of, so one of the things that could happen is the jury gets excused, the court addresses the witness, talks to the witness about the and some of this is actually in our record in this particular case. What were the circumstances in which you saw the defendant? How long did you see him? What was the lighting? What were the conditions? Similar to if you were to do sort of an independent source.
Excluding the ID? What would those questions be asked with an eye towards? Potentially excluding the ID?
Potentially, in essence, ruling that the ID should have been excluded and then asking the jury to disregard in that scenario.
So it sounds to me like you're saying, what the judge is going to do is ask a series of questions, perhaps allow counsel to ask a series of questions.
Sure.
To determine whether or not there really was subjectivity.
Because the
But if
issue
we
is,
decide as a matter of law that there is, again, what could possibly be the way to deal with that?
so there was, so you're saying after that whole encounter was?
Once the witness is on the stand.
Yes. So at the end of that, sort of, if defense counsel asks questions, attorney asks questions, judge asks questions, there's a determination that the.
No, that was what you asked. That was your answer. I understood that. I think I understand your position.
No, I just
No,
wanted
I
to.
understand your position.
Okay.
Okay.
Just to finish that thought, I think what you're driving at and what the goal is to ensure that the in-court ID is reliable. So I believe in your scenario, if the witness is on the stand, those questions are to determine whether the ID was reliable. And if the ID was not reliable, then the ID should be disregarded, if that's what the judge determines after an inquiry like that. I believe that would be my answer to you, and I hope that answers your question there.
Thank you.
If there are any other questions? Thank you.
Thank you.
Can I just ask one question?
Yes.
On the notice and a hostile witness? Because there may be occasion, like in a gang situation, where the prosecutor doesn't have the opportunity to talk to a witness and decides, I'm going to put this witness on the stand, whether because of fear or whatever, and just see if they could make an identification. There wouldn't be an opportunity for the prosecutor to know that they would be an ID. Would you consider that as an exemption, or is that up to the trial court and the trial court's discretion? What would you do in that situation?
The notice that we would be looking for would be notice of the intent to ask the question. So we aren't anticipating that the prosecutor is always going to know what the witness is going to say. Sometimes there is an element of unpredictability to witness testimony, but the prosecutor will know that they're going to ask that person to make the identification, and that's what we're seeking.
I thought that was the scenario here. I thought the prosecutor, in response to the judge, who was as surprised as the defense counsel, said, I don't know that the witness is going to ID the defendant.
That is what she indicated to the judge and to
Would
counsel.
you agree, in following up on Judge Singus's question, that there may be circumstances, for example, there are some other jurisdictions that have concluded that there may be good cause for a first-time in-court ID, as opposed to a blanket rule that there may never be without any notice?
Yes, I think that's along the lines of what Connecticut, Massachusetts, recently New Jersey have held, and the good cause or good reason framework is really sort of what I was getting at earlier with respect to circumstances where maybe identification is not a central issue in the case. Maybe the identification that's going to be made is essentially confirmatory if the witness has had some familiarity with the defendant. So that would be a showing then that the prosecution could make in response to the defense request that this ID be precluded or that there be some type of special procedure, that there would be a showing that it's not necessary. But in the absence of that special procedure or a good reason, these identifications should not be admissible.
I'm sorry, could you work through, I may have missed it, what what the burdens are in what you've just described? Like, who's carrying the first burden? Does it shift? Who's carrying that burden? Does it shift back?
So I think initially, the prosecution has the burden of providing notice that they intend to ask the witness to make the identification. I think defense would have the burden of making that request for whatever special procedure is appropriate under those circumstances. I think there'd be a case-by-case element to that. In response, the prosecution could then make a showing. They would have the burden of showing that those procedures are not necessary because there's some good reason for that, that the witness was previously familiar with the defendant, or identity's not at issue, those types of things.
And do you think that that's a separate hearing, or could that take place at sidebar? Could it take place like once they see a witness list and somebody asks for an offer of proof on the witness's testimony? How do you envision that?
I don't think it would necessarily have to be an evidentiary hearing with testimony. I think it would happen, I think in most cases, similar to other pretrial evidentiary rulings. It would be on papers, attorney colloquy, things like that. And it would be similar to what courts are doing in other contexts. And as Judge Halligan referenced, what courts are saying in other jurisdictions should also be done. And I would just conclude by saying that the overall concern here is, I would agree with counsel that it's the undue suggestivity of these identifications and their impact on the reliability of the identification is really the issue here, and that unreliable eyewitness identifications play a tremendous role in wrongful convictions. This court has recognized that in Boone and other cases, and we're asking the court to recognize that today as well. Thank you.
Thank you.